Welcome back to criminal law class. This is on section 18, the Offences Against Person Act 1861. My name's Nasir Fizi. I am a solicitor and a senior lecturer. Welcome to class. In this class, the learning objectives are to understand the actus reus and mens rea of section 18. Master the essential elements required to prove this serious offence where the victim is an ordinary person and when the victim is a police officer. It's also to analyse real life scenarios, apply section 18 principles to practical situations and case studies. And finally, to compare section 18 and section 20, identify key similarities and differences between these related offences. As always in these classes, there are a set of true and false questions as well as single best answer questions style. So this slide refers to the true and false question, so have a look at it. Let's go through each question. Question 1. True or false, section 18 is the most serious non-fatal offence against a person under the Offence Against Person Act 1861. Second question, true or false, section 18 is triable either way and can be heard in the magistrates court or the Crown Court. Question 3, true or false, the maximum sentence for section 18 is life imprisonment. Question 4, true or false, the actus reus of section 18 is identical to section 20. Both require either wounding or grievous bodily harm. Question 5, true or false, there is a practical legal distinction between the term cause in section 18 and inflict in section 20. Question 6, true or false, to establish liability under section 18 for the ordinary victim, the prosecution must prove intent to cause grievous bodily harm. Question 7, true or false, recklessness alone is sufficient mens rea for section 18 in all circumstances. Question 8, true or false, where the offence is committed against a police officer during an arrest, section 18 can be satisfied by intent to resist arrest plus an intention or recklessness as to some bodily harm. Question 9, true or false, evidence of planning, weapon use, repeated actions or the severity of the assault may be indicators of intent to cause GBH under section 18. And final question, question 10, true or false, if the prosecution cannot prove intent to cause GBH under section 18, a charge under section 20 may be more appropriate. Let's look at a series of single best answer questions. The first two are relatively in the easy camp. The third one is hopefully a little bit more challenging for you. Question 1, the defendant plans to attack the victim after weeks of arguments one evening. The defendant awaits outside the victim's house with a kitchen knife. When the victim appears, D lunges at him, slashing his face and leaving a deep cut. Defendant later admits, I wanted to scar him permanently so he'd never forget me. Which is the most appropriate charge? Is it A, battery, B, section 39, common assault? Is it C, section 47, ABH? Is it D, section 20, GBH? Is it E, section 18, GBH with intent? Then look at question 2. During a heated argument, the defendant picks up a glass bottle and swings it at the victim, hitting him on the arm. The glass shatters, causing deep cut that requires stitches. The defendant tells the police, I only meant to give him a warning, maybe a little cut to scare him. I never meant to cause serious damage. Which is the correct legal position? Is it A, defendant is guilty under section 18 because he caused a wound with intent to cause some harm? Is it B, defendant is guilty under section 20 because he did not intend to cause grievous bodily harm? Is the answer C, defendant is guilty under section 47, ABH, because he intended only to scare the victim? Is the correct legal position D, D is not guilty of any offence because he did not intend serious harm? Or is the answer E, D is guilty under section 18 because recklessness is enough for ordinary victims? Now let's look at single best answer question 3. On a Friday night in the city centre, defendant and his friend Jack get into a fight outside a nightclub. When the police arrive, PC Smith approaches Jack to arrest him for a fray. As Smith grabs Jack's arm, D shouts, "You're not taking him in tonight." The defendant then pushes Smith away forcibly in the struggle. Defendant smashes a pint glass he is holding against a wall and swings the jagged remains at Smith's head. Smith ducks, but the glass cuts across his cheek, breaking the skin and leaving a visible scar. Witnesses later testify that defendant shouts, "Run, Jack, I'll hold him off," as he's attacked. When interviewed, defendant admits, "I wasn't trying to seriously hurt him, I just wanted to give him a scratch so he'd let go of Jack. I knew he might get cut, but I didn't want to cause anything worse than that." Which is the most appropriate charge? Is it A, battery because the injury was not intended to be serious? Is it B, section 47 ABH because the injury interfered with comfort but was not life-threatening? Is it C, section 20 OAPA because D only foresaw minor harm, not GBH? Is it D, section 18 OAPA resisting arrest variation because the defendant intended to prevent lawful arrest and foresaw harm? Or is it E, section 18 OAPA ordinary victim variation because wounding a police officer always counts as GBH with intent? Now let's look at section 18, which is the most serious non-fatal offence. Section 18 represents the most serious non-fatal offence against the person under the Offence Against the Person Act 1861. This gravity is reflected in its maximum sentence of life imprisonment. As an indictable offence, a section 18 cases can only be tried in the Crown Court before a judge and jury, emphasising its severity within the criminal justice system. The statutory definition is contained in the Offences Against the Person Act 1861. Whosoever shall unlawfully and maliciously by any means whatsoever wound or cause any grievous bodily harm to any person with intent to do some grievous bodily harm to any person, or with intent to resist or prevent the lawful apprehension or detainer of any person, shall be guilty of an offence and shall be liable to imprisonment for life. This archaic wording from 1861 creates the framework for understanding one of the most complex offences in criminal law. Now, this slide seeks to represent some overlap between section 18 and section 20. It pretty much boils down to having the same actus reus. Non-fatal offences tend to overlap, making understanding challenging. Same actus reus as section 20, both require wounding or causing grievous bodily harm. There are multiple variations though in section 18, creating 4 distinct offence variations. The complexity arises when mens rea is considered, as section 18 encompasses multiple offences within a single statutory provision. Let me try and explain what that is. So, looking at this, there are 4 ways to commit section 18, and it basically boils down to ordinary victim and police victim, and whether a grievous bodily harm has been committed or a wounding. So look at it. Ordinary victims unlawfully and maliciously causing grievous bodily harm with intent to cause grievous bodily harm. That's the one. The second way is ordinary victims unlawfully and maliciously wounding with intent to cause grievous bodily harm. Look at 3. Police victims. This is where police are the victims of an assault. Unlawfully and maliciously causing grievous bodily harm with intent to resist or prevent lawful apprehension. And then look at the final variation, police victims again, unlawfully and maliciously wounding with intent to resist or prevent lawful apprehension. So simplified categories, you can see variation 1 and 2 relate to the ordinary victim, and you can see that the actus reus for variation 1 is GBH, variation 2 is wound. Then you look at the, and both have variation 1 and variation 2 is where the mens rea is an intention to cause GBH. Then look over to the next part of the slide, which is variation 3 and 4. This is where the police officers are victims. Variation 3 relates to where the actus reus is GBH. Variation 4 relates to the actus reus being wound. and then you look at the mens rea. Mens rea for both variations 3 and 4 is an intention to resist or prevent arrest plus an intention or recklessness as to actual bodily harm, causing some harm. Hopefully this categorization is a simplification for understanding, not strictly a legal definition. So you can see the actus reus has two pathways. One is wounding, breaking the continuity of the skin. Both layers must be broken. And the actus reus can also be committed by causing grievous bodily harm, really serious harm, more than trivial or transient injury. The actus reus definitions mirror those of section 20, with the key difference being the use of the word cause rather than inflict for grievous bodily harm. Now, just to make this clear, there's the section 20 refers to inflict, section 18 refers to cause, and there's a judicial puzzle which was resolved by Lord Steen in Var versus Burstow. I'm not saying that the words cause and inflict are exactly synonymous. They are not. In the context of the Act of 1861, there is no radical divergence between the meaning of the two words. So basically, he's acknowledged that Lord Stein acknowledges a difference but didn't explain what it was. But for practical purposes, let's just state this very clearly. There's no practical distinction existing between inflict and cause in modern law. Now, look at the mens rea for section 18. This is a high threshold generally, but note the difference between ordinary victims and where police officers are victims. So where it's an ordinary victim involved, the mens rea is intent to cause grievous bodily harm. Or where the police are victims, the mens rea is, there are two elements to this: intent to resist or prevent an arrest, plus an intention or recklessness as to some actually bodily harm if resisting arrest. The mens rea threshold for section 18 is deliberately high. Recklessness alone is insufficient if the victim is an ordinary member of the public. The prosecution must prove specific intent, making this a challenging offence to prosecute successfully. But note the difference where the victim is a police officer. Now I want to look at this slide where you may have a problem style question or you have a single best answer question and you're trying to prove intent to cause grievous bodily harm. This is through not necessarily through the words of a confession made by a defendant or an accused, but somebody who is acting in a particular way. So evidence indicators of intent to cause grievous bodily harm just by actions alone are clear planning. Premeditation shows intent. The use of weapons suggests serious harm intended, like a baseball bat. Repeated actions such as punching or stamping multiple times, and the severity of the attack, the nature and duration of the assault. Of course, each case turns on its specific facts. There's no single factor is determinative, but you can see these are indicative of an intent to cause grievous bodily harm. And just to re-emphasize this point again, where the mens rea, where the victims are police, it's two elements. It's an intent to resist or prevent an arrest. The defendant must intend to resist or prevent lawful apprehension of any person. And it also includes malicious harm. Defendant must intend or foresee that some actual bodily harm would be caused. This dual requirement means that they merely resisting arrest is insufficient. There must also be an intention or recklessness as to causing harm. There are a couple of practical prosecution challenges. Well, firstly, you've got the high mens rea threshold. Proving specific intent to cause GBH is challenging and requires substantial evidence, especially for ordinary victims, but you can see from previous slides what those indicative factors are, like, for example, repeated actions and the use of weapons. Rare recklessness cases in police victim cases only successful where ulterior intent to resist arrest can also be proven. And also consider alternative charges. Other offences may be more appropriate where intent cannot be established, e.g. Section 20, where you've got ordinary victims, or even possibly Section 14, where you have police officer victims, where you can't necessarily prove the specific mens rea. So have a look at this case study. This is Steve and Tony, where the victim, Tony, is an ordinary victim. The scenario in this situation is Steve lunges at Tony with a kitchen knife, causing a deep cut to Tony's face. Situation A is direct intent. Steve admits his aim was to scar Tony permanently. He has direct intent to cause grievous bodily harm and therefore satisfy the mens rea for Section 18. Look at Section A, Situation B, lesser intent. Steve states his aim was only to cut Tony in a minor way. Although he intended to wound, this is insufficient for Section 18 because it's an intent to cause grievous bodily harm. And its recklessness as to GBH would also not satisfy the mens rea. Look at case study 2, the arrest scenarios where you have a police officer as a victim. So scenario A, PC Tony arrests Steve for a public order offence. Now Jack lashes out at the officer so Steve can escape, causing a small cut to PC Tony's face. So actus reus analysis. Jack has wounded the officer by cutting his face. The cut results directly from Jack's assault. Size is irrelevant for wounding, so he satisfies that element. Look at the mens rea. Jack didn't intend GBH, but intended to help Steve escape, preventing lawful arrest. He was also reckless as to causing some bodily harm. That's the cut. So both elements satisfied. Jack can be prosecuted under Section 18. Remember, this is where you have a police officer as a victim. So you can see, hopefully, Section 18 versus Section 20 key differences. The actus reus is the same. Wound or cause GBH in Section 18, Section 20, wound or inflict GBH. And you can see from previous case law, it has no practical difference between cause and inflict. Now the mens rea is slightly different depending on if you have a police officer as a victim or you have an ordinary person as a victim. Here mens rea is intent to cause GBH, which is where you have an ordinary victim, or an intent to resist arrest plus an intention or recklessness as to actual bodily harm. And with Section 20, it's intent or recklessness as to some harm. And then you've got maximum sentences. Section 18 is life imprisonment and Section 20 is 5 years imprisonment. And when it comes to court cases, when it comes to Section 18, it's an indictable only, so it can only be dealt with at the Crown Court. And for Section 20, it's an either way offence. Sentencing hierarchy, this slide shows this. You can see this: Section 18, life imprisonment; Section 20, 5 years imprisonment; Section 47, maximum sentence is 5 years imprisonment; and then you have the common assault offences, simple assault and battery. They have 6 months imprisonment. Practical application and tips. This is what I suggest you do. Analyse the facts carefully. Look for evidence of planning, weapon use, or repeated actions that suggest intent to cause serious harm. Focus on intent. The key distinction is proving specific intent to cause grievous bodily harm, or recklessness is insufficient except in arrest scenarios where the victim is a police officer. And then also consider alternative charges. If intent cannot be proven, Section 20 or other offences may be more appropriate and achievable. Going back to the Section 18 true or false questions, feel free to pause this, check what your answer would be with the next slide. This is the next slide with the answers. And then look at the scenario single best answer questions, question 1 and 2. Check what your answer would be by looking at the next slide. This is the next slide with the answers. Feel free to pause this video. Look at the next slide, single best answer question 3. Check what your answer would be and look at the next slide for the answer, which is here. And feel free to pause and read the explanation as well. So the summary, 3 key points. Statutory frame. Section 18 creates the most serious non-fatal offence, punishable by life imprisonment and triable only in the Crown Court. It's an indictable only offence. The actus reus similarity, the physical elements mirror section 20, both require wounding or grievous bodily harm with no practical difference between cause and inflict. Note the mens rea distinctions. The crucial difference lies in mens rea. Section 18 requires specific intent to cause GBH, except in arrest scenarios where recklessness suffices if coupled with intent to resist. Look at this slide, which is a summary of all the 5 non-fatal offences. Take that in. Finally, thank you for watching. If you have any questions, put them in the comment section. And look, please don't forget to subscribe as well. It's important, and like and share the video with fellow students too.